I welcome you all for the class, and we are continuing with the Constitution, Article 31. Some of our friends have asked about the present status of Article 31. So in the last class, we have seen Article 31, right to property, which was deleted through 44th Constitutional Amendment Act 1978. And the case of Vidya Devi, in which the Supreme Court has declared in January 2020 that right to property, though deleted from the fundamental rights, part 3 of the Constitution, it continues to be the human right, more valuable than any other rights. Today we will continue with the rest of the provisions of Article 31. As I said, though Article 31 was deleted from Part 3, this part, that is Part 3, still has two provisions which provide guaranteed right to compensation in the case of acquisition of private property by the state. What are the two occasions already now available under Article 31 or the entire part? Entire part, two rights are available with regard to property. What are the two rights? Number one, when the state acquires the property of minority education institutions under Article 30, then they are entitled for guaranteed compensation. Second is when the state acquires the land held by a private individual which is under his personal cultivation and the land is within the statutory ceiling limit under Article 31A. Kindly understand, two rights are still available with reference to property in Part 3. What are those two cases? Number one, when the state acquires the property of minority educational institutions under Article 30. Similarly, when the state acquires the land which is under personal cultivation of an individual and the state is within the statutory ceiling limit under Article 31A, in that case also he is entitled for guaranteed compensation. I have already told you the first provision regarding minority education institutions was added through 44th Amendment Act 1978. The second provision was added through 17th Constitutional Amendment Act 1964. These are all important from PT point of view. So the first one, minority education institution, protection of property with a guaranteed compensation, this was added through 44th Constitutional Amendment Act 1978. And the second provision was added through 17th Constitutional Amendment Act 1964. So, now, under Article 31, though it is deleted, there are three other articles under Article 31. What are these three articles? Article 31A, 31B and 31C. This Article 31A was added through first Constitutional Amendment Act 1951. Remember, very important, Article 31A was added through first Constitutional Amendment Act 1951. Please note that the amendment was carried out by Provisional Parliament, that is, erstwhile Constituent Assembly. Provisional Parliament, 1951, there is no Parliament as such. The Constituent Assembly which adopted the Constitution continuing as Provisional Parliament. So, that erstwhile Constituent Assembly was converted into a Provisional Parliament from 1950 onwards to what is known as 1952, till the elections are held. At that time, Dr. Rajendra Prasad was the President, Pandit Nehru was Prime Minister, Sardar Patel was Home Minister, and Dr. Ambedkar was Law Minister. Remember, all these eminent personalities were members of Constitutional Assembly which adopted the Constitution. From the examination point of view, you should also understand one more point. When this first Constitutional Amendment Act 1951, was carried out in 1951, there was no Lok Sabha. There was no Rajya Sabha. In 1951, when the first Constitutional Amendment Act was carried out, there was no Rajya Sabha. Why? In fact, Rajya Sabha was established only in 1952. So, the Constituent Assembly was functioning as provisional parliament. Constituent Assembly was functioning as provisional parliament. So, there is a difficulty. There is no Rajya Sabha. You want to make out a constitutional amendment. Constitutional amendment under Article 368 has to be passed by both the houses of parliament. So parliament is combined now. Lok Sabha and Rajya Sabha put together is a provisional parliament. There is no Rajya Sabha. How can you overcome this difficulty? So, President of India invoked Article 392. Remember, very important from PT point of view. President of India invoked Article 392 and removed the difficulty of absence of one chamber of parliament. So this presidential order of 1951, removing the difficulty of absence of Rajya Sabha, was challenged in the Supreme Court in Shankari Prasad versus Union of India case of 1951, October 1951. The Supreme Court upheld the presidential order under Article 392. Presidential order issued under Article 392. So kindly understand relevance of Article 392, why the President of India had to invoke this. So it was the original that First Amendment Act was passed only by the Parliament. There was no Rajya Sabha. So the President invoked 392 and issued a presidential order removing the difficulty, which was challenged in the Shankari Prasad versus Union of India case of 1951 in the Supreme Court, and Supreme Court upheld the presidential order. Now, see, immediately after independence, and especially after the Constitution came into force, there was lot of difficulty for the government. There was necessity to undertake certain proactive, affirmative and progressive measures in the larger interest of the people, especially for the interest of the poor. It was rightfully anticipated that there would be roadblock and these measures would be contested in the court and the legal battle would be long drawn. So, as expected, the government, to overcome this situation, they brought out Article 31A, an addition to the Article 31. That is, Article 31A was added and it was intended to save 5 categories of laws, 5 categories of acts from being challenged in the court and possibility of being invalidated on the ground of violation of Article 14, that is equality before law and equal protection of law, and Article 19, 7 freedoms, freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form union and associations, and freedom to move throughout the territory of India, freedom to reside and settle any part of India, freedom to acquire and hold, dispose of property, freedom to undertake any business, trade or any avocation in any part of India. So this possibility of being attacked on these grounds were anticipated. What are these 5 categories? Primarily they relate to agricultural reform, that is land reforms and industry. First, let us see what are those. Number 1, acquisition of estates. Acquisition of estates like Jagir, Inam, Miafi or other similar grant. This is number 1. Number 2, taking over the management of the properties by the state. Number 2. Number 3, amalgamation of corporations. Number 3. Number 4, extinguishment or modification of the rights of the directors or shareholders of the company. Number 5, extinguishing or modification of the mining rights. These are all the 5 categories under which if any law is made under Article 31A, those laws cannot be challenged in the court of law on the ground of its inconsistency with Article 14, 19 and 31. So this was the implication, this was the need for Article 31A, remember. In short, as I told you, any law made for implementing the 5 categories which I told you just now cannot be challenged on the ground of its inconsistency, with Article 14, 19 and 31. Remember, this article also provides for payment of compensation at market value if the state acquires the land held by an individual under his personal cultivation and the land possessed by him is within the statutory minimum ceiling of the land. If that is the case, then in that case the compensation, guaranteed compensation at market value is available. Most important, this article 31A, does not protect from judicial scrutiny of state laws. Again I repeat, this article 31A does not protect the laws made by the state legislature from judicial review unless the state bill was reserved for consideration by President and the President has given the consent. Then you just apply your mind kindly. Why President? Because if President has given the consent, it means that the Parliament has given the consent. What is this President and Parliament? Where is the connection? Yes, President is part of Parliament. See what is the composition of Union Legislature? Union Parliament consists of President, Lok Sabha and Rajya Sabha. So with this we will end the class. We will take up Article 31B tomorrow. Thank you.